Good morning, everyone. Welcome to our eviction prevention workshop. This morning we have a guest speaker, and she's very knowledgeable. And her name is Dipti Pedikiti Smith, and she is the Director of Advocacy at Legal Services of Northern Virginia. Prior to joining Legal Services of Northern Virginia, Dipti served as a law clerk at the District of Columbia Superior Court for Judge Russell Kanan and Judge Stephanie Duncan Peters. Dipti graduated from Temple University with a Bachelor's of Science in Biology and the University of the District of Columbia David A. Clark School of Law. Dipti worked for AmeriCorps at an elementary school in West Philadelphia. Dipti is a recipient of a number of awards, including the 2018 Virginia Legal Aid Award, the 2016 City of Alexandria Chamber of Commerce 40 Under 40 Emerging Leaders Award, and the 2016 Virginia Lawyers Weekly Up and Coming Leader in the Law in Virginia Award. Dipti was born in India and spent her early childhood in India and Nigeria. After arriving in the United States, she lived near Philadelphia. She now lives in Fairfax with her family. And working in housing in City of Falls Church, I know all the housing people rely on Dipti to give us the information. So you guys are in for a treat today. So Dipti, if you would like to begin your presentation.
Great. Good morning, everybody. Thank you for joining us. I'm happy that we're having this opportunity to just share information with you all. 2020, there were a lot of changes amidst the confusion, stress, and trauma. The laws were continually changing, new policies. So I'm hoping we can get this information to you. So Dana, I just want to confirm that you can see my screen, eviction defense during the pandemic. Okay, perfect. So I will go ahead and get started. So during, in our office, we often categorize evictions in two categories: formal evictions and informal evictions. A formal eviction is usually an eviction that occurs when a landlord forcibly expels a tenant from the residence. I'm sorry, that's an informal eviction. And so majority of the evictions are attributed to non-payment of rents, and landlords may evict tenant for a variety of reasons, including property damage, nuisance complaints, and lease violations. So a formal eviction occurs when a landlord carries out the eviction through the court system. And so today we are going to talk a bit about this formal process. And if you are involved in the informal process where there is no court case yet, however, you're facing some of these issues, you definitely should contact your local jurisdiction, the housing offices, and you can contact legal aid as well. Compared to other parts of Virginia, Northern Virginia has historically experienced lower eviction rates. However, parts of our counties have higher eviction rates. And this is often a mask for ongoing housing instability because of a lack of affordable housing. And these are just some numbers. I wanted to give you more of the first half of last year, because we have more solid data on the first half. And almost 55,000 evictions were filed in the first half, with more than 19,000 eviction judgments issued between January and July of last year. While this represents a decrease from previous years, this is primarily due to the federal moratoriums on evictions and evictions issued by Fannie Mae and Freddie Mac, and also through additional income that was issued through the unemployment insurance funds in the CARES Act. So this is just a table of our local jurisdictions and the eviction filings. So across the region, landlords have filed more than 2,400 evictions in January. And this table shows that in 2019, this region experienced a spike, with increasing more than 5,000. And you'll notice that in the upcoming, this past year, they lowered as a result of these moratoriums that were in place. And this table highlights those areas where eviction, COVID, and unemployment overlap. When these health and economic factors are present in the same communities, they can heighten housing instability and undermine the COVID pandemic mitigation efforts. And for Northern Virginia, which again might have had lower eviction rates generally, there are zip codes that have higher eviction rates, that have higher COVID positive rates, and also they have higher unemployment insurance claims that are filed in these zip codes. So today we will talk about a number of new laws, and these laws are important. You know, the data that I just spoke about, it's important to recognize those numbers are lower than they could have been because of the moratorium. Some numbers are lower because of rental assistance, and we're hoping those temporary policies can become permanent, and we will talk about those new changes today. So the Centers for Disease Control issued an eviction moratorium in September, and it was set to, there were several extensions, and the most recent extension allows the moratorium to continue through the end of March 31st of 2021 for cases involving unpaid rent. To use this eviction moratorium option, each person on the lease is required to complete a declaration and provide it to the landlord. The tenant has to make sure they make all best efforts to get rental assistance, and there are income requirements if the tenant can't earn more than $99,000, or if there's a joint or married return more than $198,000. The tenant must be unable to pay full rent because of a substantial loss of income or extraordinary out of medical expenses. And the tenant must, again, make best efforts to pay timely the rent that is owed, and to close to the full payment as possible if it's feasible. And if evicted, the tenant will likely become homeless, or they will be moved to forced quarters where they're living with others. And you know, that's important. The CDC order says that an eviction crisis is also a health crisis. And if people are moving in together, that's going to increase the likelihood of spread. That's going to not allow for social distancing, and other factors that could exacerbate the health crisis. So each adult on the lease, as I want to reiterate, should complete the declaration. It has to be signed, and it can be submitted by hard copy, or it can be submitted electronically. It has to be sent to the landlord. And if you are in a large apartment complex and there's a management office, you can submit it to that office as well. The order applies even if you have been evicted for non-payment of rent after September 4th, 2020. As I mentioned, the CDC order went into effect September 4th of 2020. So you can still provide this declaration and apply for rental assistance, and you will be able to prevent an eviction if the funding is paid. You can still be evicted for non-rent related reasons, as I mentioned. And so these are for cause reasons. If it's, like, as I mentioned earlier, like noise complaint, or it's the end of the lease. You know, our office is challenging whether or not you can evict someone if it is end of the lease. It hasn't been solidified or determined by courts yet, that we're aware of. So we will still challenge them, but it's something for you to note that can be a reason for eviction. And if the landlord pursues a case, even when you are covered by the CDC declaration, they could face criminal penalties. Tenants could also face criminal penalties if they submit a fraudulent declaration. So in Virginia, prior to 2020, in Virginia, the landlords for non-payment of rent will give you a 5-day notice, and that law recently changed. So landlords now have to give you a 14-day notice if you cannot pay rent. Landlords can evict you for unpaid rent that resulted as because of the pandemic. The landlord must apply for the rental assistance program on behalf of the tenant within 14 days of serving this notice, unless the tenant tells the landlord, I've already applied for rental assistance. So if you're late on rent, the landlord has to give you this 14-day notice, and it has to tell you the amount that's owed. Within those 14 days, the landlord also has to apply for rental assistance. If the tenant is applying, the landlord has to provide documentation to the tenant. And these are documents that are required by law that are under the funding law. And so the landlord needs to provide W-9, IRS form, and other supporting affidavits. There are exceptions to this non-eviction rule. The landlord can evict if the tenant refuses to apply for rental assistance or cooperate with the landlord's application. If the application for rental assistance is not approved within 45 days of applying, the landlord can proceed with eviction. We are defining 45 days, the time period to start once the full application is submitted with the agency that is accepting the application. So if I submitted the application or my application today, and the agency tells me I still need the landlord to submit a W-9, and next week I end up submitting the W-9, and that's when my full application is complete. The 45 days will start running next week. If there is a subsequent application for rental assistance and that's not approved in 14 days of applying, the landlord can evict the tenant. If the tenant doesn't qualify for rental assistance, the landlord can proceed with eviction. And if rental assistance is no longer available and the state runs out of money, then the landlord can start eviction proceedings as well. Apologize, I think I had the wrong slide. The Virginia Rent Relief Program is the first place that many tenants can go to apply for rental assistance. So prior to, I think, February, this program was called the Virginia Rent and Mortgage Relief Program. They recently changed their name to Virginia Rent Relief Program. To qualify, the tenant must have a valid lease in the name or other documentation confirming the landlord-tenant relationship. And this can be very, it does not have to be a formal, typed up lease. It could be in an email. It could be on a piece of paper. But it has to show that there's some sort of landlord-tenant relationship. What if the tenant applies and they're eligible, but the landlord is not providing the needed signature? So the tenants are the state is encouraging the tenants to keep the email documentation to show their support team of their attempts to contact the landlord and request assistance. And then tenants are encouraged to contact their legal aid office because the Virginia Housing cannot give legal advice. If you are a student in housing and you're not eligible for the rent relief funds, but if the student is with a parent, they're on a lease, and the parents are on a lease, they should identify. The parents should identify themselves as the primary applicant, and all adults will have to meet the program requirement. If you have roommates, if there are multiple roommates in the same house, but only one roommate needs the rental assistance, he or she can apply for their portion. The applicant doesn't need to include the other roommate's income on the application. If eligible, the portion of the rent will be prorated and paid directly to the landlord. So if you have previous housing a debt. So the state program does not provide assistance for expenses from previous rental homes. A tenant can only receive aid for their current housing, rent, and fees. So if you're a tenant in a federally subsidized housing, public housing or low income housing, tax credit properties, applicants with those forms of assistance are eligible for rental assistance, but only for the tenant portion of their arrears, not the current or future month's rent. So if you are someone that's living in hotels, motels, or other sort of long-term stays, you can still be eligible for rental assistance. So but you are considered a tenant if you are there for 60 days or more, and then you can provide documentation of your stay. Then the rental agreement can be used in lieu of a lease. If you are at a manufactured home, parks and lots, you are eligible for rental assistance as well. If you have a rent to own agreement, you are also eligible for assistance, but applications using either of these agreement structures must proceed as tenant applications through the Rent Assistance Support Center. Now, to know whether or not you experience loss of income during COVID, you have to show that you've been laid off, your place of employment has closed, you experienced a reduction in hours, you have to stay home to take care of your children because daycare closed or school closed, you have to stay home for childcare due to distance learning, that you lost spouse support or child support, you had increase in expenses because of childcare or medical bills, or that you are unable to find employment due to COVID. The rental assistance program may ask you for income verification. If you have no income, they have a certification, what's called zero income certification. And this can be completed for all adult households members. And this is done within is done by the applicant within the support center's application. So to qualify for the program, you have to have a rent amount that is at or below 150% fair market value in Northern Virginia. So we have figures here, as these are the estimates. So if you have rents that are lower than these amounts, you may be able to qualify. If you have gross income at or below 80% of area median income, you would qualify, and the amounts are set forth here. Again, this program, the rental assistance program, transitioned on February 1st, so they're no longer accepting mortgage applications. And I'll provide more information if you do have require mortgage assistance, where you can go towards the end of this presentation. So landlords may apply using this portal. As I mentioned, tenants can apply as well. Once you've submitted your application, a confirmation email is sent to the applicant along with a request for supporting documentation if you didn't submit everything that was required. When you apply as a tenant or a renter, the application requests an email address for your landlord or property manager. After all the documentation has been received and attached to the application, the landlord or property manager will receive an email with the landlord-tenant household agreement with a copy to the applicant. The landlord, again, must submit their paperwork as well, which includes the W-9. So this program will only pay past due rent from April 2020 to the present, but tenants may reapply monthly if needed. The program application process for tenants changed in December. Just to note, now it goes through the state, except for in our service area, Fairfax County, they've developed their own portal, and I will provide their information in just a second. Once your application is complete, it may take between 10 to 12 business days to process after all the needed documentation has been submitted. And a complete application, again, is once all the required documents are submitted. So the Fairfax County, when the federal legislation passed, the state received, I guess, maybe about $56 billion for rental assistance. The Fairfax County decided to take their portion of those funds. So if you are a tenant in Fairfax County, you can still seek rental assistance, but you will need to call coordinated services planning. If you are a landlord in Fairfax, you can access the landlord portal, which is located on their eviction prevention page. And they also have an email address where you can email for support. I believe they also have a specific contact for landlords who need assistance. If a landlord owns 5 or more units or more than 10% interest in 5 or more units, they cannot take any action to evict you for unpaid rent unless the landlord also offers you a repayment plan. So the first step, just to summarize the previous slides, the landlord has to apply for rental assistance. Say you don't qualify for rental assistance, but your landlord fits into this category where they own 5 or more units. The landlord has to offer a payment plan that allows the tenant to pay the amount owed in equal monthly installments over either 6 months or the remaining time under your lease, whichever is less. So if you have a 7-month lease, and you'll have 6 months to pay the balance. This repayment plan cannot include late fees. Tenants must give landlords a signed statement certifying their loss of income, explaining the reasons I said above. If one of those applies, they can talk about their increased expenses, and they should agree to the payment in writing. The landlord only has to enter into a payment plan once during the rental agreement. Landlord, again, cannot take eviction action unless the tenant does not enter into a repayment plan within the 14 days of receiving the notice, or if a tenant enters into a repayment plan and fails to make that payment within 14 days, that could be a reason for eviction. However, if the tenant misses a payment and they default on this repayment plan, the landlord must issue another 14-day notice. So if once these notices are issued and you don't qualify for rental assistance, you're unable to enter into a repayment plan, and there's just no other options for you, the landlord may at some point file an eviction action. And we've had landlords, that's sort of assuming all the options are exhausted, and we have many landlords that'll file prior to any of those options being exhausted as well. So when you go to the first court date, the initial hearing, which can also be referred to as the return, a tenant who experienced, again, any loss of income during COVID, due to COVID, can request a 60-day continuance in an eviction case for non-payment of rent. So they will need to appear in court at the initial court date. So different jurisdiction it has a different meaning in all of the jurisdictions. Some courts will allow you to call in Some courts may not have that option, so you may need to find out, call your local court to get more information, or you can contact our office, or you can go to the Northern Virginia Affordable Housing Alliance webpage, and they have more information. So if you're impacted by COVID, or you're in a vulnerable population and you can't go to court, you can call the court and ask for an accommodation. So before you appear in court, you want to have with you at court written proof that you were affected by the state of emergency by showing a pay stub, a letter, showing the reduction in earnings or reduction in hours. Again, another bill was recently passed to clarify that this letter can just state that there was a partial loss of income, and that should be enough to grant you the 60-day continuance. The 60-day continuance will, that option will end 90 days after the current state of emergency ends. So landlords who own 5 or more rental units, think here. So the 30-day termination notices also apply to properties covered by the CARES Act. And these are federally subsidized properties. The moratorium for federally subsidized properties ended at the end of July. However, there was a provision in there that said after the moratorium ends, if you want to evict a tenant, you have to issue what's called a 30-day notice instead of, what I'm describing, a 14-day notice. There are many arguments that could be made that it doesn't apply. We are arguing that it does apply, and I understand that some landlords are following this protocol. So we would urge you to contact our office if there is any question on this issue. If you have to move, whether it's that you can't pay rent, you need to move in with another roommate to afford rent, you may need to submit another rental application. So landlords who own 5 or more rental units cannot take any adverse action. That means incorrectly deny you housing based solely on the payment history, or an eviction for non-payment of rent. That happened between March 12th of 2020, and it ends 30 days after the state of emergency. So this is still ongoing currently. Once the landlord, and so this means they can't hold it against you. If you apply for future housing and they see that you have a debt or an eviction for unpaid rent, they can't hold that against you, and they have to process your application. If they are denying you housing, they have to provide you a notice of the denial, so that you have a right to contest it. They have to provide the legal aid number on that denial so you can contact us. You have to assert your challenge within 7 days of the denial, if it's mailed and it starts from the date it was postmarked, or if the landlord sends you an email or phone, you have until the close of the next business day. If the landlord fails to follow this new law, the tenant can recover up $1,000 in statutory damages and attorney's fees. So there are a number of protections against foreclosure. You want to make sure that you are receiving the appropriate notices, especially when you're in default. There was a question as to whether or not payments can be made in full before the sale. Yes, that can be done. You can enter into repayment plans. You can enter into repayment plans agreed by the lender. And you can also have file for bankruptcy, but oftentimes, especially now when individuals don't have enough income to stabilize themselves, this would not be an appropriate plan at this moment. So federally backed mortgages, I mentioned earlier, those are loans that are usually given through Freddie Mac, Fannie Mae, FHA, HUD, USDA, and the Veterans Administration. So under the CARES Act, they're permitted to give you a 180-day forbearance, plus you get another, you can renew it for 180 days. The protections under CARES may have ended under on December 31st of 2020, but many banks are still offering this forbearance option. Moratorium on foreclosure. So these federally backed mortgages, they issued their own moratoriums. Fannie and Freddie, the moratorium exists through the end of February, and FHA, HUD, VA, and USDA moratoriums apply through the end of March. Our understanding, just from talking to different aides for legislators, they anticipate this moratorium extending, but that's yet to be seen. So if the moratorium does end, you can still contact your lender, you can enter into a payment plan, and you can request a modification of the loan. You can also request a 30-day continuance. You have to show loss of income as it relates to COVID. You have to provide the written notice to the bank in several different ways, including a pay stub showing the reduced income from March 12th, a furlough letter, any other evidence that's acceptable to the bank, and then you can ask for a 30-day stay of the foreclosure. I mentioned earlier that the Virginia Rent Relief Program used to be named Virginia Rent and Mortgage Relief. The state is not offering mortgage assistance anymore. However, we encourage you to call 211 or your county to see whether they have mortgage assistance. Some jurisdictions do, so you want to make sure you utilize those resources. So if you find yourself in court for various reasons, as I mentioned, you will get a notice, and I put this up to note that it used to be a 5-day notice. However, I mentioned you are now getting a 14-day notice. So once the notice is provided and the landlord feels that these steps haven't been taken, where rental assistance was not granted or the tenant didn't cooperate, they may ultimately file an eviction action. So it's called a summons for unlawful eviction, and you'll receive a date when you have to appear in court. If you don't go to court, a default judgment can be entered and the landlord can continue with eviction proceedings. So you want to appear in court, and you don't physically have to appear. You can call your court to see if there are other ways you can have an accommodation, such as calling in. The first return, you can ask for the 60-day continuance if needed. However, if you are still in the rental assistance process or you haven't received the notices, you want to note that to the court. Once the case is continued, the next date that will be set by the court is a trial date. This is when you will present your evidence and put forth your defenses. If you win, the case will be dismissed. If you don't win, it's likely that the court will issue what's called a writ of eviction, which is allowing the landlord to continue the eviction process. You can appeal the decision, but oftentimes tenants can't afford to appeal it because they have to post a bond, and most tenants don't have the money to post the bond. Once the writ of possession has been issued, the landlord can go to the sheriff's office and ask the sheriff's office to set an eviction date. And as of right now, and the sheriff's office has to give you a notice before they actually come and lock the doors. And the law requires a minimum 72-hour notice. So if there is any notice, if the landlord, even if you lose in court, you do not have to move out. You can still proceed with rental assistance. You can still file the CDC declaration if you're not completed the rental assistance process. And you can still file. Okay. So oftentimes in the middle of trying to resolve rent issues, there may be other issues that lead to conflict between the landlord and tenant. So the landlord may lock out the tenant or cut off utilities, and the tenant does have a remedy. It's called a petition for relief from unlawful exclusion. So it's a document that the tenant can file to either ask that the landlord restore the utilities or let them back into the home. The law changed, whereas previously you had to give notice to the landlord. The law changed so that you can file the document and you can show that you tried to give the landlord of the notice of the hearing. And when you go to court, you may get an emergency ex parte hearing where the judge will give you a temporary order, for example, letting you back into the home. And then a full hearing will be held within 5 days of issuance of that order. This new law will begin next year. Currently, every time there's an eviction filing against a tenant, it stays on the court record for at least 10 years. Even when the lawsuit is dismissed. This can make it more difficult for tenants to secure rental housing. And so starting next year, if an eviction action is dismissed or non-suit is taken, a tenant can file a petition to expunge the court records that's related to the eviction lawsuit after 6 months. If the unlawful detainer action was dismissed or non-suit was taken, then the court, without a hearing, can enter the order requiring the expungement once the petition is filed. So that is my presentation. I know I went through it quickly and there was a lot of information. I actually have not been checking chat. I don't know.
I don't see any questions right so far, Dipti, I don't. Oh, I do see one question. Let me see. I don't see a question right now. If anyone in the workshop has a question, if you would submit your question, then I will bring that to Dipti's attention. Give it just a second. I don't see any questions. Dipti, thank you so much for that wonderful presentation. I think that you have covered a lot of information that we would have. And I just wanted to remind everyone, if you have friends or family who should see this session, please direct them to our Facebook page at the Northern Virginia Housing Expo or our webpage which is novahousingexpo.org, where they will find a video of the session later this afternoon. This is a free session on a different topic there's a free session on a different topic on the second Saturday of every month all year in English at 11 and in Spanish at 1. So visit the website. Once again, that's novahousingexpo.org to sign up or tune into other sessions. And also, if you feel like you would benefit from some one-on-one financial counseling, free sessions are available with both English and Spanish speaking certified counselors. You can schedule a time convenient for you on our website at novahousingexpo.org. So once again, I just want to give just a few seconds. If anybody has any questions that they would like to ask, please feel free to go ahead and put those in. Oh, it seems like there are a few questions. I don't. Cameron, I don't see the questions. I'm looking
Sure.
for.
So it looks like there's one question from Chiquita Haskins, and she's asking, is rental assistance still available for Arlington County?
Yes, definitely. You can call the state program, but the county has their own rental assistance program as well. So you should, if you can call the county phone number, and if you do receive a notice from the landlord, they should provide the state phone number as well. But if you need to know more about the resources in Arlington County, another number you can call is 211.
Awesome. Additionally, does the CDC declaration still work after I lost my court case?
Yes. Our office often advises individuals to complete the declaration, especially if it's a non-payment of rent related case. We have many tenants that are still in the rental assistance application process. And so the eviction will be stayed generally, so that the rental assistance process can be completed. And as I mentioned, there might be an increase in filings related to expiration of leases. There is a split on whether or not the CDC declaration applies to leases that expire. Our office thinks it does, and there's some other advocates that agree. It's just not been tested in court, or there's no order that I'm aware of. And so if you do have a lease expiration case and you can continue to pay your rent, we advise that you contact us and we can see whether we can assist you in court. I do know that the sheriff's offices, if the landlord is asking for a writ, they have to file an affidavit with the court explaining that they went through all the steps that I just described with the 14-day notice, applying for rental assistance. And so a writ right now should not be issued unless those requirements have been fulfilled. Again, if it was issued at a prior date and there may be other circumstances, in which case you should still file the CDC declaration if it applies, and you can contact our office for further assistance.
Dipti, I also see someone would like your email. If you could give your email address so that they could reach you.
Sure. I think I can type. I don't know if I can send it to everyone, but I can send it to you. I don't know if it went through.
Okay, everyone, Dipti's email address is dpidikiti@lsnv.org. And we also send it in the chat to all, everyone that's here. We also put it in the chat. So you should be able to look at the chat and also see that address.
You should, and you can look at our web address as well, www.lsmv.org. That has a lot of the information I just went through. You can apply for our services online or call, and our number is 703-778-6800.
Thank you, Dipti. I don't see any other questions. Does anyone else have any other questions? Because I don't see any. Don't see any more. Thank you all, everyone who attended. Dipti, thank you for that excellent presentation. This was very helpful, and I know from personal experience that I mean, she is the expert for Northern Virginia. So if you have a question, she is the person. So thank you everyone for attending, and please reach out to us if you have any further questions. Thank you very much.
Thank you for having me.